Hearing the appeal of Gol Linhas against MatlinPatterson Global Opportunities.
Yes, good morning.
Good morning. I'm Vernon Flynn and I appear with Emily Wood in her last appearance as a junior for the appellants. Mr. Lowe QC appears for the respondent with William Jones and Noor Kalek of Ogier. Now, there are formally 4 grounds to the appeal, but they really fall under 3 heads. Firstly, there was no relevant consent. Secondly, no opportunity to be heard on Article 148. And thirdly, that the award dealt with an issue outside of the scope of the submission to arbitration. Now, if we win on any one of our grounds of appeal, then we succeed, but for one issue. The respondents submit that even if we win on all grounds, then the court should nevertheless exercise its discretion to enforce the award. Now, this would mean that the award ought to be enforced, notwithstanding that on this basis, my client never agreed to arbitration of any kind, is not a stop from maintaining that it didn't consent, enforcement is contrary to Cayman public policy, and Article 148 didn't fall within the scope of the reference. Now, in my submission, that only has to be stated to be rejected. Lord Mance in Dalla said that it would be remarkable if such a discretion to enforce were exercised when there was no substantive jurisdiction. We submit that's something of an understatement. And I'd like to begin with a bird's eye view of the facts, then put my submissions in context, and then deal with each of those 3 heads of appeal.
Thank you.
In a nutshell, my clients found themselves liable for a third-party tort of malice in an ICC arbitration under an agreement which they did not sign, where they had only signed a non-compete obligation in a side letter, where the jurisdictional basis for their being bound was said to be as a party, but liability was found as a non-party in tort, where the tort claim was not simply inconsistent with the basis for jurisdiction, but was never advanced by the claimant, nor stated in the terms of reference, and thus outside the scope of the reference. Now, we do not accept that there was ever any basis for any such claim under Article 148, but there was in any event no opportunity to defend themselves on the most serious findings of malice against my clients. And to cap this, my clients haven't received a single cent from the transaction. And I mention that because of something Justice of Appeal Rick said in the Court of Appeal. Now, I do want to say a little about the facts. I know the panel will have read all of the relevant material, but in very brief summary, my clients, the MP funds, are private investment funds headquartered in New York. Their capital is provided by institutional investors such as insurance companies, corporate and government pension funds, and other large financial institutions. Now, as you know, the heart of the case concerns a share purchase and sale agreement dated the 28th of March 2007, which was governed by Brazilian law and ICC arbitration seated in Brazil. Now, the MP funds are not party to the share purchase and sale agreement. The sellers were indirect subsidiaries of the MP funds, and the evidence was that it was common industry practice for private investment funds not to be party to contracts entered into by portfolio companies. That was evidence given by our witness, Mr. Weiss. You don't need to turn it up, but it's in the electronic bundle at page 183. The MP funds did give an undertaking that they wouldn't compete with the business for a period of time. And that undertaking was contained in a non-compete letter, which was annexed to the share purchase and sale agreement. It is worth turning that up. It's at page 660, and I just asked the panel if they wouldn't mind. It's a very short document. If they would just read that to themselves.
Yes.
Now, the non-compete letter didn't contain an arbitration agreement, and it set out in its entirety the terms of the non-compete obligation applicable to the MP funds. In 2007, a dispute arose as to the operation of the price adjustment mechanism in Clause 5 of the share purchase and sale agreement. and that dispute was eventually referred to arbitration on the 27th of December 2007. Now, the claim in the arbitration wasn't simply against the sellers, but also against the MP funds on the basis that they were the alter egos of the sellers. And then about a year later, there was an additional argument that the tribunal had jurisdiction over the MP funds by reason of the non-compete letter. Now, in a partial award dated the 7th of April 2009, the tribunal held that the dispute didn't arise under or in connection with the non-compete letter, but by majority it held that the non-compete letter rendered the MP funds party to all the terms, including the arbitration clause. Now, I'll come to the basis for that in the course of my submissions, but for the moment I will just note there is no case advanced by the respondents before this court that there was ever actual consent to arbitration. The only cases that my clients are stopped from denying that. Those are the core facts relevant to jurisdiction. There are some other facts which are relevant to the right to be heard, and they can be stated very shortly indeed. The claim in the arbitration, as found in the ICC terms of reference, was under Clause 5 of the Purchase and Sale Agreement. Now, in relation to the MP funds, the tribunal rejected the alter ego argument. They found the MP funds liable in tort, a tort of malice, under Article 148 of the Brazilian Civil Code, in the amount of the contractual measure. Now, no such claim was ever advanced by the sellers, nor put to the MP funds. No notice of that claim was given, nor was there ever any opportunity to address it. Now, it is not, therefore, just a matter of being deprived of the opportunity to address the tort claim, but it was also inconsistent with the basis upon which the majority had found jurisdiction, namely that the MP funds were party to the arbitration. If parties, how could they be liable as third parties for the tort claim under Article 148? Now, in the Court of Appeal judgment, there is a hint of a case against my clients that they ought reasonably to have predicted an award under Article 148, even though it was inconsistent with the basis for jurisdiction, and even though it was never advanced by the claimants in the arbitration, and it wasn't pleaded in the ICC terms of reference. And there is one other important fact, and it's important because it seems to have exercised Justice of Appeal Ricks, and we suggest coloured his approach to this case. It is the finding in the judgment that once paid, the purchase price of $275 million had been removed by the MP funds from the sellers, and the sellers were left essentially without means. The uncontroverted evidence was that the MP funds were not recipients of the purchase price. And I would like to just show you where that is in the bundle. It's page 184. It's Mr. Weiss's evidence at paragraph 15. It's the last sentence of his evidence. The MP funds were not recipients of the purchase price.
Could you just remind us, please, or remind me of the passage in Sir Bernard Ricks's judgment where he deals?
Of course, Sir, my Lord. That's page 90 of the bundle, and is in the judgment at paragraph 10.
So what was the evidence then about?
I'll show you that. So at the end of paragraph 10, once paid, the price of $275 million had been removed by the MP funds from the sellers, and the sellers were left essentially without means. So the evidence from Mr. Weiss was that the MP funds were not recipients of the purchase price, and it's our case, although there's no finding, that the MP funds lost over $400 million on the transaction. And I'll just show you where that is. If you go to the bundle at page 1932.
What is that?
This is my client's final submissions on the merits in the arbitration. Just look at paragraph 208. You'll see, in addition to this, despite the distortion of the facts by the plaintiff.
Sorry, which paragraph?
208, my lord. It's just the first sentence at the bottom of the page, 1932 of the bundle.
Yeah.
What is this document?
This is my client's final submissions on the merits in the arbitration, and the submission has recorded it, but as I say, there's no finding one way or the other. At page 2177 in the award, at paragraph 578.
It was submission.
Yeah, that was submissions, and that was our submissions, and this is the
award now.
This is the award. I make it clear, there's no finding. This issue was not an issue until it was raised by Justice Appeal Ricks in the Court of Appeal, as to what happened.
Hang on one moment. So we're now looking at electronic file 578.
Page 2177.
2177. Okay.
At paragraph 578. And I'll make it very clear, this is simply reflecting our submission. There's no finding one way or the other, but this is the closest we get in the record to the position. And you'll see at 578, on its part, Respondent 4 begins its defence by alleging it never used the legal personality of either Respondent 1 or 2 to defraud any third party. What has been proven is that Respondent 4 indirectly invested 400 million in VRG and in Respondents 1 and 2, and nothing has been recovered.
Where did the purchase price go? Is there any evidence about that?
There isn't any evidence in the record one way or the other. Yeah, that is the core point.
There is in the arbitration awards at 2087 to 2088, paragraph 132.
Which page is that?
2087. So which paragraph, Mr. Lowe?
132, my lord.
132. Thank you. Yeah. Mm-hmm.
So next, I'd just like to say a few words about the Brazilian and other proceedings. Before the Cayman Islands Court of Appeal, the Brazilian proceedings remained extant, but they have now been finally and conclusively determined, and they've come to an end. And so that disposes of one issue which arose below. The issue of whether the Brazilian court is applying the same test is still very much an issue. Now, after the award was given, on the 10th of January 2011, VRG applied to the United States courts in New York to have the award recognised and enforced against the MP funds and under the New York Convention. The US courts refused to recognise and enforce the award at first instance and in the Court of Appeal on the basis that the MP funds were not party to the arbitration agreement. Now, my clients don't seek to contend that this gives rise to an issue estoppel, recognising that US courts decided the question of jurisdiction as a matter of US law, but it is notable, as was recorded by the US Court of Appeals judgment, that VRG had agreed in connection with the US proceedings that the Brazilian law principles of contract interpretation governing a party's contractual consent to arbitration were the same in all respects as under US law. And you'll see that from page 2647. It's in the footnote at the bottom of the judgment.
Sorry, 2647.
And remind me, what are we looking at here?
But this is a judgment of the US US court.
This is the Court of Appeals of the Second Circuit, isn't it?
Yes, exactly.
Right.
And if you look at the footnote at the bottom of the page, parties are in agreement that the standard principle of contract separation is no different under Brazilian law than under our own. Now, VRG's expert evidence in Cayman was principally that which was given before the US courts. but my client served expert evidence directed to the issues in the Cayman Islands. And you'll have seen in the record, our expert is referred to as either Mr. Santos, Mr. Gom, or Mr. Gom Santos. He's the same person. And the reason the panel have been referred in the cases principally to his expert evidence is because neither of VRG's experts, Mr. Justi or Professor Carmona, gave any evidence on the critical issues. That is, what test was being applied by the Brazilian court, except that Mr. Justi did give some evidence directed to this, and he stated that jurisdiction was a matter within the exclusive jurisdiction of the arbitrators. You'll see that from page 229.
Paragraph.
I'm so sorry. It's
229.
48.
yes. That's. Apologies.
Thank you.
Yes, I'm so sorry. It's paragraph 48. It's 229, where he says, "It is in my opinion that the determination of the intention of the parties is subject to the exclusive jurisdiction of the arbitral tribunal, whose freedom to decide that issue is guaranteed by Article 21, paragraph 2 of the Brazilian arbitration law." So his evidence was actually contrary to the position that it was a matter that would be ultimately determined by the court. His evidence was it was subject to the exclusive jurisdiction of the arbitral tribunal.
Well, they can give themselves jurisdiction.
Well, that's his evidence. That's what he says, which is completely contrary to our position. But that's the evidence that's coming from the other side. And given that the issue was, are they applying the same test? Are they applying a de novo test? It's a surprising proposition, but it's completely against their interests to put the case in that way.
Well, there's no hint of that in either of the Brazilian judgments. I mean, whatever else the judgments were, I mean, if you're right that they were just a review, that's obviously an issue to be decided. But
yes,
from recollection, there's no hint in either of them that this is a sort of, as it were, a slam dunk because it's all a matter for the arbitrators.
But I think that comes into the question of, it's not so much, was it a de novo review by the Brazilian courts? That's ultimately the issue. What's interesting about, there's no evidence apart from this. They don't address the issue. And this issue is completely contrary to their case. So, Julian, you're absolutely right that ultimately it's about what the Brazilian courts decided. But in my submission, it's quite striking that on the core issue, there is no evidence from the respondents' experts. Two of them, neither of them give any evidence. And I'll show you later an extract from Professor Carmona, where Professor Carmona, in an article, is advocating a very limited intervention by the courts in arbitration cases, which may explain why there was nothing from him on the standard of review. I totally accept, Lord Legate, it's also a surprising proposition that you can pull yourself up by your own bootstraps, which is what the courts in this jurisdiction have absolutely set their face against, from Azov and Baltic to Dalla. We don't allow the tribunal to pull themselves up by their own bootstraps. But given that this is an issue, the only evidence that bears on it says the opposite of their case now. And that's a surprising proposition in my submission. Obviously, can only go so far. The reaction of the US court in the enforcement is also instructive. As I've shown you, they found that the MP funds weren't a party. And that although it's not in any way binding on the court, it does give the court some comfort that what we're asking for is that has actually, which is not to have the award enforced because there was no consent. It was also the result found by the US courts. We don't say it's binding in any way, but it is comforting. They're applying the same principles of construction, and they reached the view that the MP funds were not a party. And the US courts may also be one of the reasons why VRG didn't contend for any arguments on construction in the Court of Appeal. And they only ran the arguments of construction in a very limited way before Justice Mangatal, and I'll show you how that was put below in a moment.
But if there's an issue of estoppel, it doesn't really matter.
Well, yes, except that you're absolutely. I think Justice Peel-Rick said, well, it doesn't really matter because there's no real difference between an argument of construction and estoppel. You get to the same result. But in my submission, it is striking that you don't advance a case of construction. Before Justice Mangatal, it was put, the only reason we're advancing the issue of construction is because we don't want the court to think that it was an irrational decision. By the Court of Appeal, it was completely abandoned. There was no argument on construction. But it goes the other way in my submission, which is why wasn't that argument advanced? And in my submission, it's because it wasn't a tenable argument. It couldn't be justified. And that feeds into the standard that was being applied by the Brazilian courts. Because if they were approaching it on a de novo basis, the court would have had to address some very difficult arguments of construction. I've shown you the side letter. How does that letter make my clients a party to the main agreement? Now, in my submission, it's just not possible to do that, but it is something that the Brazilian court would have to have done if they advanced it as a de novo, on a de novo basis. So yes, Justice Peel-Rick says, well, it ends up in the same basis. If you don't argue construction, you can get there by estoppel. But why was that done? What was the rational basis for dropping construction? And it is important in the context of this case. Now, with that introduction to the issues, I just wanted to put the legal submissions in some context. I'll try to keep that as brief as I can. Firstly, the legal framework under the New York Convention. I'll deal with that very briefly, and then the three grounds of appeal: jurisdiction, due process, and scope of submission. So far as the legal framework is concerned, we submit the positions as follows. Firstly, the respondent seeks to enforce the award as a judgment of the Cayman Court. The Cayman Islands have brought the New York Convention into law by means of the Foreign Arbitral Awards Enforcement Act 1975. And as the panel knows, the New York Convention envisages a relatively straightforward process by which awards can be turned into local judgments. It's therefore critical that the minimum safeguards in the New York Convention, and Article 5 in particular, are adhered to. Now, the points which we raise go to consent, i.e. jurisdiction, due process, and scope of the reference. Those are all, in my submission, fundamental issues. It's not suggested, nor could it be, that the points which we raise are points which, if established, would fail to satisfy the requirements of the New York Convention.
You'll come to the scope of the reference in due course, but can it stand on its own?
If you're against me on estoppel, if the court concludes that we are stopped from taking that point, then no. But it is a very important point. It feeds into the other points. It does feed into, for example, the right to be heard, because in an ICC arbitration, the terms of reference define the scope of the dispute. But yes, it isn't treated separately, and it does feed into ground one. That is absolutely true. But it is possible to succeed on that ground alone, but not if you find that there's been an estoppel on the scope. So if we submit, if we establish any of our three grounds, then VRG isn't entitled to enforce the award as a judgment of this court. Now, we bear the burden of establishing that provisions of the New York Convention apply. But memorably, the plaintiff, in this case the respondent, has only the advantage of service, no more than that. That's the famous analogy drawn by Lord Mance in Dalla. The plaintiff doesn't start 15 or 30 love up. Limited prima facie credit is given to apparently valid awards. That's Lord Mance in Dalla. I'll give you the reference. It's paragraph 30 at page 3547. Paragraph 30 at page 3547. You don't need to turn it up. No. I mean, that's the only point I want to make clear. Before Justice Mangatal, Mr. Lowe suggested that Lord Mance was wrong in making that statement. That's a very ambitious submission. No basis was put forward for it, and it's wrong. The case is also unusual because, as I've just told you, the US courts, a fellow New York Convention state, have also considered enforcement of the award, and they rejected enforcement on the basis there was no agreement to arbitrate in respect of the matters determined in the award. Now, the US courts didn't need to and did not deal with the issue of a failure to be heard, as they didn't need to. And there was also no case of estoppel advanced in the US. But the US courts have done the same exercise, applying the same contract principles, which are persuasive on the issue of consent, and it was common ground below in the Cayman Islands there were no material differences in the contractual principles to be applied between Brazilian, Cayman, US or English law. That's recorded in the judgment of Justice Mangatal, paragraph 26 in the bundle at EF 29. You don't need to turn that up either. And below, VRG said, well, the decision of the US court was not persuasive. And they made that submission because some explanation is needed as to why the Cayman court should take, and this court should take a different approach to the US court, applying the same provisions of Article 5 of the New York Convention. So with that introduction, I'd like to turn first to the ground one, substantive jurisdiction and consent. Now, ordinarily, this would involve a two-stage test. First, was there an agreement or consent to arbitration at all? And secondly, is there an estoppel? Now, before Justice Mangatal, at first instance in Cayman, VRG advanced the argument in reverse. First, they said the issue had been decided by the Brazilian court, and secondly, the construction of the agreement under Brazilian law is consistent with the arbitration agreement applying to my clients. And Justice Mangatal was told that the construction point was only made below to show that any alleged finding by the Brazilian court was not irrational. I'll just show you where that is in the transcript. If you go to page 424 of the bundle, please.
424.
Yes. And on the right-hand side, it's the second full paragraph, beginning the question. Do you see that?
Yes, thank you.
The question of whether or not there was an agreement, I would ask you to look at it this way. And that is what my cross-examination is all intended to achieve. It's not my object to persuade you to apply Brazilian principles of contract law in order to determine whether there was an agreement. You don't have sufficient evidence to do that, because the evidence you do have, I accept from my learned friend submission, is the principles of Brazilian contract law. The high-level principles are agreed, and there isn't sufficient evidence of the more detailed nuances of Brazilian contract law for you to come to a different conclusion, as if you were deciding it for yourself. But as you know, I'm going to invite you to find that the issue was decided by the Brazilian court. And that I don't have to do this because it's no function of someone relying on an issue estoppel to persuade you that the foreign court was correct. I don't have to do this. But I wanted to simply show that the foreign court didn't behave irrationally as some form of rubber stamp and did consider the issue and may have had something in mind. You'll see in a while, well, that is plausible when you look at the judgments. So that was the way it was put at first instance. And even that fig leaf was abandoned in the Court of Appeal. And we submit that's significant in two ways. Firstly, the logical order is reversed. One would ordinarily say that the construction is correct, and secondly, it had been decided by the courts as a res judicata. Now, we suggest that the reason it's put in this order is because the plaintiff always had little faith in their arguments on construction.
Well, that's a jury point, Mr. Flynn.
Well, it isn't quite a jury point, because if there were, the question is, why did they abandon that? Why? And it feeds into the task that this court has to do in this appeal.
Well, you don't, what they did or didn't do isn't the relevant thing. You may make a perfectly valid submission that looking at that letter, it doesn't look as though there was any agreement.
Yes.
But what order they chose to put their arguments in isn't going to assist us in answering the question. If I were arguing it, I'd put issue estoppel first, whatever the merits of the underlying point, because if there's an issue estoppel, you don't have to worry about those.
But I suspect that your lordship wouldn't have abandoned construction, which is what happened in circumstances where
It doesn't matter, though. At this point, my lord's putting because if there was an issue estoppel, then it doesn't matter whether the Brazilian courts were right or wrong.
Can I explain why it does matter? And the reason it matters is this. Because the issue that the court is concerned with is whether there was a de novo review. And the reason that construction is relevant to that is because the issues on that include those which would arise on construction. How does a non-party amend the agreement? How does one obtain an express manifest agreement to arbitrate from the side letter? How can the side letter incorporate all the terms of the main agreement? What rational reason is there for entering into a side letter if the intention of the parties was to enter into the main agreement? How does the restatement of clause 11.1 bring in other clauses? What is the explanation for the conflicting theories of construction under Brazilian law that were advanced below? So I totally accept your lordship's point that in one sense it doesn't matter, but in this case it does, because when one is looking at the Brazilian judgments, And the case against me is that there's been a de novo review. If there had been a de novo review, the Brazilian court had to address and answer those very questions.
I can understand that point, but that doesn't depend on how the other side put their case. It depends on the fact that you submit that it's very difficult, if not impossible, to find a rational basis for the outcome that was reached.
Absolutely, my Lord. So, yes, your Lordship's right. So, in one sense, but it is striking, my Lord, because what Justice of Appeal Rick says is it doesn't matter. I think that was the point that Lord Hamlin put to me. Does it really matter if you can get home one way? But why did they give that up? Why did they give that point up? And the reason is, in my submission, is to try to sidestep the difficulties on construction in the Brazilian judgments themselves. And so it's just, well, the Brazilian court has decided it. You don't need to look very carefully. It was a de novo review, even though they don't advance any expert evidence to that effect. But those issues don't go away. So I think for the purposes of the panel, is to make it clear that those, when one is looking to the Brazilian court to see, did they do a de novo review, or did they give deference to the award? Those are the questions that would arise on a de novo review, and they weren't addressed. Justice Mangatel concluded, and we say impeccably, in her judgment, paragraph 145, you don't need to turn up page 65 of the bundle, it seems obvious on the face of the non-compete letter that it does not contain or incorporate an arbitration agreement. Absolutely right in my submission. It doesn't. And that, therefore, is the context in which the alleged estoppel arises. There can be no sustainable argument in my submission. There was, in fact, consent. But what's being said is that my clients are bound by the determination of the Brazilian court on the basis it was a de novo review. So as I say, it does remain relevant in this sense, which is that in order to undertake the exercise of analysing the Brazilian judgments, in the absence of expert analysis from the respondent, you would have to look at what the exercise was being done by the Brazilian courts in the abstract. And again, I'll come to that, but in my submission, that's a completely inappropriate exercise in the absence of expert evidence. So far as estoppel is concerned, it's not simply that the court is looking only at estoppel rather than construction. There are two red flags. The first is that the authorities rightly require caution in finding an estoppel based upon a determination by a foreign court under foreign law. There's rightly caution there. One of the reasons is because the English court doesn't necessarily know precisely the procedure and how things are done in a civil court. And secondly, the red flag is, in my submission, that as a bare minimum, VRG had to advance a case in expert evidence that there was a de novo review by the Brazilian courts. And they didn't do that. Neither of their two experts advanced any such case. Now, just pausing there, I'll just deal with one point raised by VRG, and it is the decision of this court, and Lord Lloyd Jones in particular, in Brownlee. And I think it is worth just turning that up. It's at page 3640 of the bundle. It's paragraph 148 of Brownlee.
Sorry, 3640, did you say?
3640. In fact, 3638, actually. Paragraph 148.
38.
Yes.
363.
3638, paragraph 148. And we accept what is said in paragraph 148. Just picking it up from 3 lines down, the old notion that foreign legal materials can only ever be brought before the court as part of the evidence of an expert witness is outdated. Whether the court will require evidence from an expert witness should depend on the nature of the issue and of the relevant foreign law. In an age where so much information is readily available through the internet, there may be no need to consult a foreign lawyer in order to find the text of a relevant foreign law. On some occasions, the text may require skilled exegesis of a kind which only a lawyer expert in the foreign system of law can provide. But in other cases, it may be sufficient to know what the text says. If, for example, the question is whether a spouse has a right to claim damages for bereavement under the applicable foreign law, producing a copy of relevant foreign legislation with, if necessary, an English translation is a much more secure basis for finding than presuming that the foreign law is the same as English law. Of course, a judge needs to be alert to whether the text relied on is current, but even if that cannot be guaranteed, the presumption of continuity may be a more reliable foundation in the absence of contrary evidence, and the presumption of similarity.
Mr. Flynn, I'm very happy to have that attributed to me, but I think it's Lord Legate, in fact.
Oh, is it? I'm so sorry.
How to make yourself popular.
Well, I do apologise to both of you in that case. So now, what I would say about 148 is this. We completely accept what is said there. Flexibility is key in relation to expert evidence. There's no doubt about that. There are issues in court and in arbitration about how expert evidence is produced. But in my submission, that cannot in no way justify the approach in this case, which wherever you draw the line, this fell on the wrong side of that line. VRG did have 2 experts on Brazilian law. Neither addresses the issue. And this is a case where, in my submission, it was essential to have guidance from foreign law experts. Now, to get home on estoppel, VRG has the burden to show that the Brazilian court had decided the same identical issue. Justice Mangatal held that the issues weren't simply not identical, but not even materially or substantially the same. She held that at paragraph 135 of the judgment, at page 60 of the bundle.
Is it the case that is it your case, or so put the other way around, is the only basis on which you say it isn't the same issue to do with whether or not it was effectively some form of review?
Yes.
It's just that
de novo.
So it all comes back to the same.
Comes back. At the heart of this aspect of the case is de novo review. Okay. Below, there was another issue about whether the Brazilian proceedings had come to an end. That's now gone. So it comes back to de novo review. Also, I should just say that the construction also comes in on this as well, because they've accepted construction, and so under the New York Convention, there isn't in fact on construction any consent, so that VRG have the burden of proving the estoppel. Now, we say it's essential for a party who alleges there's been a de novo review to adduce a positive case by expert evidence in a case of this kind. They would need to explain the legal context, the procedural background, the nature of the test which was and could be applied, and the basis upon which it said that there was in fact a de novo determination. That would include, for example, the significance of the absence of live evidence. In this jurisdiction, famously in Azov and Baltic, which was the first case under the Arbitration Act 1996, there was a complete retrial. There was a trial before arbitrators. There was a trial before the court. The whole thing was repeated. But this court, nor this court, nor the Court of Appeal, nor the first instance judge, have any of that evidence. None of that was done. Neither of the respondents even addressed such a case. Now, we submit that in a case like this, it is absolutely not permissible to seek that type of case on an issue of foreign law and procedure by way of submission from counsel. In contrast to the other points taken on foreign law, such as construction issues, estoppel wasn't dealt with by way of expert evidence at all, but by passing up the Brazilian decisions and the supporting material to the court and making submissions on them. Now, whatever degree of flexibility is appropriate in the modern world, in my submission, that is not appropriate. And Brownlee doesn't begin to justify such an approach to an issue like the present one. And we suggest that the reason the respondent couldn't positively advance such a case by expert evidence because it couldn't be done. Their case is entirely contrary to the clear guidance in Dicey and the authorities as to how the proof of foreign law should be done in an English court. And his experts literally say nothing about issue estoppel at all. We don't need to turn up the cases, they're in the bundles, but foreign law must be proved as a fact by expert evidence, subject to those limited cases where that wouldn't be necessary because it's a very straightforward point and the court is satisfied that it has the material which is necessary. It can't, in general, be proved merely by putting the text of a foreign enactment before the court or by citing decisions or books of authority. That has to be done as part of the evidence of an expert witness in a case of this kind, because the court cannot properly evaluate them or interpret them. But that is exactly what happened before Justice Mangatal and the Cayman Islands Court of Appeal, to pass up the Brazilian proceedings in translation and seek to explain them to the court. And as I say, the only justification for that is paragraph 148 of Brownlee. And in my submission, whilst that provides welcome flexibility and approach in the modern era, it does not begin to justify the approach in a case of this kind. And particularly where there's expert evidence in any event. Paragraph 148 would be very significant where the court's dealing with a very narrow issue and it can avoid the need for expert evidence at all. There was no avoiding expert evidence in this case. They had 2 experts. We had 1, but they didn't put in any evidence for them. So it's not simply the approach to expert evidence on foreign law. It also ties in with the fact that particular caution is required before a foreign judgment is held to give rise to an issue of estoppel. And that is really a connected issue, and that is because one of the reasons for the caution is because it can be very difficult to determine exactly what the foreign court decided and the basis for which it did so. I would just like to remind the panel of 2 authorities on that. First, Carl Zeiss, the judgments, firstly of Lord Wilberforce at 4402.
Page?
So page 4402 at 967A to E of the judgment.
4402.
Do you see it starts as a matter of principle?
Nice.
As a matter of principle, and we really are throwing back on principle, whether the recognition of judgments is based upon a recognition of vested rights or a consideration of public interest in limiting re-litigation, there seems to be no acceptable reason why the recognition of foreign judgments should not extend to the recognition of issued decisions. From the nature of things, and here it's right to recall Lord Brougham's warning, that in the case of foreign judgments may involve difficulties and necessitate caution. The right to ascertain the precise issue decided by examination of the court's judgment, pleadings and possibly of the evidence may well in the case of courts whose procedure, decision-making technique and substantive law is not the same as our own, make it difficult or even impossible to establish the identity of the issue there decided, without attempted here to be raised, or the necessity for the foreign decision. And I think that it would be right for a court in this country, when faced with a claim of issue estoppel arising out of foreign proceedings, to receive the claim with caution in circumstances where the party against whom the estoppel is raised might not have had occasion to raise the particular issue. The fact that courts can, as I've stated, examine the pleadings, evidence and other material seems fully consistent with this right to take a broad view of the result of the foreign decision. But then he says, in principle, but with these reservations, where after careful examination there appears to have been a full contestation and a clear decision on an issue, it would, in my opinion, be unfortunate to exclude estoppel by issued decision from the sphere of recognition. So there, just one of the statements of caution. The other extract I wanted to just show you is Lord Justice Clark, as he then was, in the Good Challenger, at page 4909. Just one small extract in paragraph 54, subparagraph 2. Starts paragraph 54, it's on the right-hand side. The authorities established there must be a full contestation and a clear decision on the issue in question. And then he refers to Carl Zeiss. And then at 2, the courts must be cautious before concluding that the foreign court made a clear decision on the relevant issue, because the procedures of the court may be different and it may not be easy to determine the precise identity of the issues being determined. Now, we submit that there is no sustainable basis for the suggestion that the judge was wrong to find that VRG had failed to establish that there was a de novo review by the Brazilian court, especially in the absence of any expert evidence from them to that effect. And we submit there's no basis for overturning the judge on that issue. So how did Justice of Appeal Ricks overturn Justice Mangatal in those circumstances? And the first point, he says, is that the issue on estoppel is much the same as to whether bound is an issue of construction. And I accept that to a certain degree, as I've made it clear, but I do submit that the abandonment, complete abandonment of the construction argument does impact, and it does mean that it's not a legitimate way of avoiding the issues on construction. Where in the Brazilian judgments do the judges grapple with these fundamental issues as to how consent was given? And we submit it also shifts the starting point under the New York Convention, because the starting point is there is a lack of consent. The only defence is estoppel, not construction itself. And I say, even in any event, the burden under the New York Convention is on the party seeking to resist enforcement, but it only has the advantage of service. It doesn't start 15 or 30 love up. So as construction had been abandoned, the issue was then firmly on VRG to demonstrate and establish the estoppel. In my submission, that's particularly difficult given the caution required and the absence of any expert evidence from them. Now, in order to succeed on estoppel, it was necessary to find that the issues in Brazil and Cayman are identical. And Justice Mangatel made that finding. As I said, she said it wasn't identical. She said they weren't even substantially or materially similar. But the core question was the obvious one. And Sir Julian, that was the point you were asking about. It comes back to what standard was the Brazilian court applying?
You accept the issues are identical?
Not if, no, I don't accept that. It's only, boils down to, was there a de novo review?
Well, I understand that.
Yeah.
Yeah, but in terms of what they were determining, whether de novo or by review.
It comes back to, yes, it comes down to, it boils down to, was it de novo or was some deference given to the award? And if so, what degree? Was it a review of some kind? Was it clearly a de novo consideration? That's what it boils down to. Now, to get there, the Court of Appeal have said, and we submit wrongly, they say that the Dalla approach is adopted globally. In other words, the whole world applies a de novo review. Now, you've seen what the only point of relevance their own expert addresses. He says there's exclusive jurisdiction given to the tribunal, which is completely contrary to that. And the key point in Dalla itself was, what degree of deference does the English court give to an award? And in this jurisdiction, Dalla decided that an English court wouldn't show deference either to the facts or law found in the award.
Where does Sir Bernard say that in his judgment? It's adopted globally?
Let me find that for you.
Don't worry if you haven't got it.
I'll get you a reference to that.
Miss Wood, I'm sure.
Yeah, she'll have it at her fingertips. But I do want to show you why we say that's wrong. It would be a surprising thing. It's one of the major issues with the whole issue of competence, which is what is the deference that's given? Now, in this jurisdiction, no deference is given at all. But in my submission, it's absolutely not the case that that is the position adopted globally. If you go to 2850 of the bundle,
yeah,
we have an extract from Professor Bourne's highly respected...
2850.
Yeah, 2850. You'll see there in the paragraph beginning, despite a general standard of de novo review and the refusal of many national courts to grant formal preclusive effect to arbitrators' jurisdictional rulings, courts in a number of jurisdictions have accorded a substantial degree of deference to arbitrators' factual determinations and legal conclusions. So just pausing there, they don't simply defer to the fact findings. In this jurisdiction, we don't defer to the facts at all. That's why in Azov and Baltic, there was a second full trial and legal conclusions regarding the existence or validity of arbitration agreements in annulment proceedings. As already outlined, this is true in the US, Canada, Swiss, Singaporean and other national courts. This is particularly true where the arbitral tribunal has conducted extensive fact-finding, especially involving witness credibility, has expertise in the commercial sector at issue, or has particular expertise in the applicable law, especially when the reviewing court does not. In all these circumstances, although the annulment decision is made on a de novo basis, it's sensible to accord a substantial weight to the arbitrator's jurisdictional fact-finding, analysis and conclusions, and national courts generally have done so. So Lord Hamlin, the answer is, it comes back to de novo, but the question is, what is the approach of the Brazilian court? And the Court of Appeal said, Justice of Appeal Rick said, and I can give you the reference to this, that even if there's deference on the facts, there wouldn't be deference on the law. He says that in the judgment at paragraphs 133 to 135, which is at pages 138 to 139 of the bundle. You don't need to turn that up because Professor Bourne says exactly the opposite. The deference is given to law and facts. Now, that's extremely important. So that's the first point. Then the second point is the one I've made a number of times, but it is extremely important, which is that the burden was on VRG to lead evidence on the nature of the exercise performed by the Brazilian court, to explain to the court what was being done and how and why it was said that there was a de novo review. And in my submission, it would have necessarily entailed grappling with the issues of construction and explaining where they had been decided on a de novo evidence. And we did lead evidence on this, and I do want to show you that. That's at page 293 of the bundle. That's Professor Justi. And my submission gives very fair evidence. If you look at the bottom of the page at 293, starting at paragraph 210, neither the BAA nor the BCCP nor any relevant court rules expressly set out what standard of review a Brazilian court is required to apply in an annulment action under Article 33 of the BAA, whether on the questions relating to the jurisdiction of the arbitral tribunal or otherwise. And then over the page, it says at 211, in the annulment proceedings, the Brazilian courts therefore were not required to consider the matters before them de novo from the arbitration tribunal's award. In my opinion, it is very difficult, in fact, to identify what standard of review or consideration the Brazilian courts applied, but it appears they primarily reviewed the correctness of the tribunal's decision on jurisdiction, rather than considering that question de novo. In my submission, that is very fair, understated evidence. Even our own expert, the only expert who actually directly addresses this, says there is no required standard, and it's very difficult to see what standard they actually did apply, but it primarily reviewed the correctness of the decision on jurisdiction, rather than considering the question de novo.
Well, surely there has to be a required standard. I mean, it'd be unusual if the rule was that the court could decide for itself whether to apply it. I suppose that itself would be a standard, if it's up to the court to decide what intensity of review to adopt.
Yes. I mean, what our expert says is there's nothing in the rules themselves that tells you what the standard is, and there is no guidance as to what that standard is, and when you read the judgments themselves, even he, a trained Brazilian lawyer, is unclear as to what standard they apply, but it appears that they didn't apply it de novo, they were reviewing. I mean, you'll see from the case, one of the questions in the judgment, is it possible? The court itself, is it possible that they were right? That sort of question is completely inconsistent with a de novo review. They also don't grapple with the points of construction that I've mentioned to your lordships. I do want to show you the... Ms Wood asked me to answer Cecilia's questions. Paragraph 131 of the Ricks judgment at page 138 of the bundle.
Okay, thank you very much.
I should just show you the cross-examination. Now, I pause on the cross-examination, of course, because we don't make much of this, but a positive case was put to our witness, even though there was no positive case in their expert evidence at all. But nevertheless, much is made of the cross-examination, and I should just show you that. Page 435 of the bundle. Starting at line 14, this is Mr. Lowe's cross-examination of Mr. Gomes Santos. So what happens on appeal? Does the Court of Appeal, when it looks at the judgment below, look at the record and come up with its own decision with regard to what the judge did, or how does it carry exercise on an appellate court? Well, the way it's happening in Brazil, as you're aware, Brazilian arbitration law dates back to 1996, so what we have today is there's not a clear, in my understanding, standard. So the judge is going to, and then Mr. Lowe says, slightly different question, in an ordinary action, okay, I should just pause there, in an ordinary action, much is made of this ordinary judicial determination, ordinary action, but that doesn't tell you anything about the standard of review. In this jurisdiction, you can have an ordinary judicial determination, but that might be judicial review, it might be summary judgment, it might be Wednesbury unreasonableness, it may be any number of things. But he asks about an ordinary action. Okay, certainly, if you look at, well, never mind, that's what we left the judge, okay. You say that somehow the standard of review is unclear, yes, but they're not reviewing, are they, what the tribunal did? They're making their own decision on due process, for example, isn't that correct? Leaving aside the Court of Appeal for a moment, you brought up this point, so I'm going to follow it. You said that the standard of review is not clear in arbitration. Answer, right. But the judge decides an appeal, an annulment action, like any other action. Right. and he has to decide as a fact whether there's been a violation of due process. Okay, isn't that correct? And then and over the page at the top, the judge has to decide as a fact whether the conditions in Article 32 is satisfied, doesn't he? Yes. He or she, yes. Doing so, he or she is going to find as a fact whether or not there's been a violation of due process. Yes. And they're going to make that fact finding in the same way as they do any other ordinary proceeding. Correct. Because Article 33 requires the court to use ordinary rules of procedure to make those findings. Correct. Now, in my submission, that doesn't help the court in any way, because what he's asking about is what is the normal process and procedure? And the normal process and procedure is fulfilled. But that doesn't tell you anything about the standard. As I say, in this court, a non-civil court, ordinary procedures can be adopted, but summary judgment tests might be applied, Wensbury unreasonableness, fraud claims applying a different standard, any number of standards. And I should just, for completeness, just go on to line 17. Mr. Lowe says, therefore, I suggest to you that the standard of review is simply that the judge decides the facts under Article 32 for the purposes of an ordinary action, just as any other fact would be decided. He says, maybe so. Well, it must be so because the judge has to follow the ordinary rules of procedure, and we've been through what those are. Right, but what I was trying to say is that one line of thought, there's also the possibility the judge just go to the issue of the correctness of the first instance decision. Are you talking about the appeal, or are you talking about when the, yes, judge goes to the first instance decision? You mean the judge, don't you? Yes, of course. I see we're at cross purposes. So the appeal, is that...
That's the whole point, isn't it? What Mr. Lowe is asking there, or what Mr. Lowe is clarifying there, is that he was talking about on appeal from the judge of first instance to the Court of Appeal in Sao Paulo.
But that doesn't help. That's even less helpful, because the review standard of the Court of Appeal in Brazil from a first instance decision is a very different issue to the one this court is concerned with, which is what is the standard of review at first instance? Because that is where it has to be a de novo review. You may well have limitations on the review by the Court of Appeal of the first instance decision. So it doesn't, in my submission, it doesn't come close to establishing that there was a de novo review in this case. It's simply that ordinary rules of procedure apply. It doesn't tell you anything. So in this court, if you have a jurisdictional challenge under Section 67 of the Act, you're entitled to a full rehearing. You go before the commercial court judge and call your witnesses.
Mr. Lowe, we have to put, Mr. Flynn, we have to put this in context, don't we? I mean, the start of this passage of cross-examination is when he's putting to, Mr. Lowe is putting to Mr. Gom what he had said, that we don't know what the standard is.
Yes.
We don't know what review is carried on by the judge. That's line 25 on page 85.
Yes.
And he asked him a whole series of questions, putting to him, it's the ordinary standard that's applied by the courts in other cases.
Well, it's the ordinary rules of procedure.
Ordinary rules of procedure.
But that's a different matter. The ordinary rules of procedure don't get you an answer to the question of what's the standard of review. If you ask the question in this jurisdiction, what are the rules of procedure for a rehearing under Section 67? Well, you may say, well, we follow the normal rules of court. You put in your pleadings, you put in your witness statements, and so on. It doesn't tell you what standard the court is adopting.
Did he ask specifically about the question of consent? What approach to that? Because it seems to me that the example of due process, obviously the court does decide that for itself.
Yes, exactly, and that's a different issue. The questions of due process, whether there's been procedural adherence, that's a separate issue. That's an issue which is separate on the right to be heard, which is this court bound by Brazilian approaches to matters on which you're not heard? Is it jura novit curia? So even if it's acceptable in the Brazilian court, is it acceptable to the Cayman court? That's a separate issue. This is I've referred you to what my learned friend relies on. This doesn't come close to helping this court with what's the standard of review. Remember, the burden is on him to show that it was clearly a de novo review. This doesn't.
I understand that the first instance decision was some sort of summary decision. So
yes, I think.
It was an issue on appeal.
Yeah.
And they said that was fine.
Yes.
You're saying it was actually a summary review.
My case is it wasn't a de novo decision. That's all I have to show. Now, the degree of, when you look at these Brazilian materials, even our expert can't make head or tail of them. That's how difficult it is. It doesn't come close to establishing a clear de novo review. In fact, in my submission, the whole context of it, if you do undertake this exercise, which I very strongly submit is not appropriate, which is asking the court to decide on the basis of translated material with no expert assistance whether there was a de novo review. But if one does look at the judgments, it's not at all clear, to put it at its very lowest. And all I have to show is that the VRG have not established that there is a de novo review. Now, the degree of deference to the award may vary, the degree of deference on fact, law, and so on, grappling with the issues, the actual underlying issues that you would expect in a de novo review. All I have to show is that the burden wasn't satisfied. And my starting point is construction has been given up, and they put in expert evidence, but nothing on this issue. So in my submission, we don't get into that territory. As I say, ordinary judicial determination, that phrase, doesn't tell you what standard is being applied in Brazil. And in my submission, it's a phrase that's apt to mislead, because it doesn't import within it de novo review. It's about what was being asked about is the procedure. This is obviously very different to a civil lawyer. What is ordinary judicial determination? It's actually quite difficult even for an English lawyer. What does that mean in a certain context? Which standard is being applied? Is it summary judgment? Is it judicial review? But asking a civil lawyer, a Brazilian lawyer, about ordinary judicial determination in these circumstances, in my submission, doesn't come close. The heart of the case is, was there a de novo review? Nothing in the cross-examination comes close to showing that it was a de novo review. And so the attempt to suggest that our expert conceded anything, beyond that the procedure was the same, it gets nowhere. So it's not just that the only expert evidence was from our expert, but our criticism of the Court of Appeal, Cayman Islands Court of Appeal, is that the Court of Appeal did conduct its own analysis of the underlying material. And we submit that was a completely wrong approach and apt to cause error. It's rightly deprecated in the authorities, subject to Brownlee, limited exception. But the failure to provide expert evidence is one thing, but the unassisted conclusion that the standard of review was clear is another. And Justice Ricks himself concludes that Articles 32 and 33 of the Brazilian Arbitration Act are issues for the court. He holds that in his judgment at paragraph 125, page 136. But that was contrary to what Mr. Gonsantos said, I've shown you in paragraph 210 of his third report, at page 293, the one I just showed you, where he says, neither the BAA nor the BCCP nor any relevant court rules expressly set out what standard of review a Brazilian court is required to apply in an annulment action under Article 33 of the BAA, whether on the questions relating to the jurisdiction of the arbitral tribunal or otherwise. So we have evidence going one way. There is no evidence going the other way, but Justice of Appeal Ricks concludes on Articles 32 and 33 of the Brazilian Arbitration Act. Now, that has to be seen in the context of the position under Brazilian law. We put in an extract from Professor Sesta. I don't know if you've seen that. It's at 2859 of the bundle. At paragraph 2.156. Dealing with Brazilian law, the crucial question is to what extent the courts are empowered to analyse the grounds and to review the decision of the arbitral tribunal on its own jurisdiction. Referring to a conference addressed by Emmanuel Gaillard, the author of the leading book on Brazilian arbitration law, Carmona, that is Professor Carmona, who is VRG's expert, who doesn't give any expert evidence on this issue, but clearly it's a matter of some significance to him, argues that court intervention should be limited to evident cases of invalidity. So Professor Carmona, VRG's own expert, is arguing for limited intervention in a competent case, which can be recognised prima facie without the need to produce evidence. In 2013 and 2016, the STJ applied for the prima facie argument, or evident invalidity argument, to justify the judicial review of an arbitration clause in the course of annulment suits. In 2018, the STJ confirmed again the prima facie doctrine and established a very high threshold for court review of arbitration clauses.
What is that the Supreme Court, the STJ?
Yes. I believe, I'll be correct if I'm wrong, it's the Apex Court. So in 2018, the STJ confirmed again the prima facie doctrine and established a very high threshold for court review of arbitration clauses. The defect of the clause shall be so evident that no evidence needs to be produced. However, this decision was very controversial within the STJ's third chamber, and the outcome of a split vote, Justice Paolo de Tarso Sansevino pointed out in his dissenting opinion that alleged defects of the arbitration clause that, if proven, qualify as a violation of public policy, i.e. falsification of signature, should be reviewed by the courts. In the course of executor proceedings, the STJ's special court tends to apply the competence principle more strictly without exceptions. Now, putting that at its very lowest, firstly, you can see that Professor Carmona could have given evidence on this point, and this passage might explain why he didn't do so, because he's an advocate for a very limited approach, not, I hasten to add, that it's all very clear and it's a de novo review and the courts are free to reconsider completely afresh. It's all about a debate about limitation. Now, we submit that this material, all of this material, indicates that there's no proper basis for the Court of Appeal to overturn Justice Mangatal on the issue of standard of review and thus on estoppel. To put it at its very lowest, it was far, far from clear. So, unless the panel have any questions about consent, I wanted to move on to ground 2, which is the lack of due process and finding liability on a basis which was neither pleaded nor argued under Article 148. Now, I'll just set out the factual position very briefly. After finding that my clients were party to the PSA for jurisdictional purposes, by way of the non-compete side letter, the tribunal held my clients liable on the merits pursuant to a third-party theory of tort, which the claimant never raised. Now, it is important to observe that this was an ICC arbitration governed by ICC rules. Now, it is not correct, as it was said below, that by agreeing a particular seat, you incorporate the court rules applicable to that seat. The ICC rules themselves require the tribunal to identify any specific applicable rules, and there were none. And the whole point of the terms of reference defined at the outset of the arbitration are there precisely in order to define what claims and defences are submitted to arbitration for determination. And I'll just show you the terms of reference. They start, in fact, the first paragraph I want to show is 19 at page 956. You'll see it starts at the claims, 19. The arbitration concerns the performance of the price adjustment provided for in the contract. So this was a contractual claim for price adjustment under the contract. Then there's the alter ego argument at paragraph 21. Respondents 3 and 4 use Respondents 1 and 2 as authentic alter ego companies. The investments by Respondents 3 and 4 and Respondents 1 and 2 were made through mere loan agreements rather than by regular contribution of capital in order to protect the investment of Respondents 3 and 4 from the creditors. And then further details are given in 22 on the alter ego case. And then if you turn on to paragraph 20, on the next page, paragraph 29, you'll see the relief sought. You'll see it requests relief under 1, and then on 2, on the merits, it requests the arbitral tribunal to grant the price adjustment as provided for in clause 5.1 of the contract ordering the respondents to pay the value to be assessed by the arbitral tribunal under the terms of paragraph 27 above. Subsequently, if the arbitral tribunal decide that the ascertainment of the amount of the price adjustment must occur outside the scope of this arbitration, which we are not expecting, it's requested that the arbitral tribunal declare that respondents 3 and 4 shall be liable towards GTI for the credit resulting from the price adjustment, so on, under clause 5.1. So the only claim asserted against MP was to hold it liable for the contractual relief as an alter ego for the sellers, and that the contractual obligation could be attributed to my clients. The terms of reference identified no tort claims, sought no relief in terms of tort damages, and said nothing about Article 148 or malice or the forms of relief pursuant to it. And the relief included an election between rescission and damages. Now, the ICC rules provide that where the terms of reference are signed, no claims outside its terms may be added except by application to the tribunal to add a new claim. And no such request was ever made in the arbitration to add a new tort claim, and no addition of claims ever took place. So by the time of the final award, my clients were led to believe, as a matter of jurisdiction, it was being treated as a party to the contract in its own right. The only claim for relief was the amount of contractual purchase price adjustment, and the only claim of a liability against my client concerned whether the seller's contractual purchase price could be imputed to my clients on an alter ego theory.
If you were a party to the contract, why is the alter ego doctrine come in?
Well, exactly. It doesn't make sense. I mean, that's really our point, because in an ordinary case, if a claim is made in contract and a party is found liable in tort, that gives rise to obvious issues of fairness, of the ability to be heard. In this case, it goes even beyond that. Quite aside from the fact that we were never a party at all, the liability basis is completely inconsistent with the basis on which we were found to be liable for jurisdictional purposes. So for jurisdiction, we're said to be a party. For liability, we're said to be liable under Article 148 as a third party. So the answer, my lord, is it doesn't make sense. It absolutely doesn't make sense.
It was completely illogical.
Totally illogical. Totally illogical. But
if you're parties to the arbitration agreement.
The illogicality doesn't really start at the end. That's why I was very keen that the construction arguments should be put before the panel, because the illogicality of even the jurisdictional basis is there, and then you get this illogicality. It's not just, but to say it's illogical, of course, sort of in a sense, undermines quite how serious it is. This is a tort of malice. It's not even just a tort, if I could put it that way. It is completely illogical. I completely agree. So I don't think I need to say very much more about that. There is a complete illogicality in the award. We weren't liable for the purchase price of adjustment on an alter ego theory. I might just give you the references, if I may. My clients weren't liable for the purchase price adjustment on an alter ego theory. That's in the final award at paragraph 607 to 8, which is 2182 of the bundle. But we're held liable as a stranger to the PSA, a third party, under 148. Now, that was never pleaded, never identified in the terms of reference, and never added to the arbitration. You'll see that from the final award at paragraphs 620 to 638, which starts at 2184 of the bundle. And it awarded relief, tort damages, as opposed to a contractual purchase price adjustment calculation. And it equated the two without any explanation as to why tort damages for dolo or malice would be the same as the contractual prescribed calculation of the purchase price adjustment.
Well, that point's less impressive, if you don't mind my saying so, because you can see an argument for saying, well, the loss, if there was a claim in fraud, in the tort of deceit, as it were, then the damage you've suffered is the excess price you've paid for the
Yes, except
company.
That it does come in, which is one of the things said against me, is that even if my clients didn't have the opportunity to be heard, that we have to show, according to Justice Ricks, that it would clearly have made a substantial difference one way or the other. We don't accept that at all in a case where you haven't been heard on the point. But remember, this is Brazilian law. One thing I should emphasise, very important, which is not to treat it in some respects, as if it's English law, and say, well, you can see why in a tort claim under English law you might get to the same result. The tribunal don't give a reason, so we don't know. They don't explain that. It might be explicable under English law, but we're not under English law. So in my submission, we're entitled to know why that decision works, but in a sense that's at the end of the illogicality. It starts from a logical basis, but they don't even explain how they get to the result. Now, I just want to say what Justice Mangatel held at first instance. She, in my submission, rightly declined to recognise the award because it was contrary to the public policy of the Cayman Islands to enforce an award that fell foul of Cayman standards of fairness and due process. She held it's plain that the MP funds could not reasonably have foreseen that they would be held liable as third parties in tort for tort damages when the claim against them and relief sought throughout the arbitration was to hold them responsible for a contractual obligation of their indirect subsidiaries. She says so in the judgment at paragraph 172, and she sets out her reasoning at some length in the judgment from paragraphs 172 to 175. I submitted to the Court of Appeal that reasoning was impeccable, and I stand by that. It is common ground, or beyond reasonable argument, that the public policy in question is Cayman public policy. And there's no reason why the public policy in the enforcing court will be the same as the public policy in the supervising court. The only question is whether the award contravened the public policy of the enforcing court. And I will show you a few authorities on that, but it's very clear in my submission. The first is a decision of this court in Cukurova, which is at 3457.
Looking specifically at the public policy ground.
Yes, this is all public. We're dealing with issue 2, which is the failure to be heard in public policy.
But I thought you relied on due process, the fair hearing limb as well.
Yes.
More specifically.
Yeah, yes, we absolutely do. I just want to show you what the applicable test is. It's 3488.
Yeah, I was going to say 34...
Paragraph 32.
3488. Cukurova, paragraph 32.
I believe so, but I'm always a little bit hesitant about saying that. But yes, I believe it is. But if you look at paragraph 32 of Cukurova, it's not in dispute that in applying these principles, the enforcing court must apply its own concept of natural justice. In this case, that is, of course, the concept of natural justice as understood and applied in the BVI. Section 36.3 reflects Article 5.2b of the New York Convention and provides that enforcement may be refused where it be contrary to public policy. Here, the public policy of the BVI. It is contrary to public policy in England to enforce an arbitral award where the foreign proceedings violated English principles of natural justice. And so we do.
I don't think we've really been provided with enough material on this point. I mean, an English first instance case in which it wasn't in dispute is one thing, but Mr. Bourne has several sections of his book discussing cases across the world and the approach to 5.2b.
Yes.
And I've had a look at it, so I don't want to decide the case on something that the parties haven't had a chance to address. You might want to have a look at it too.
All in the same trap.
Yes. Absolutely. We're happy to do that. That's 2b, but of course your lordship's absolutely right that we're also under the right to be heard as well, which is a whole separate head. Which is possibly in this case...
Well, I meant 1b, I think, actually. It says 2b here, but it's Article 5.1b, isn't it? That is the principal provision.
Yes.
Isn't that your primary ground?
Yeah.
Yes, 1b is our primary ground. And the reason is, I can show that the clearest authority, in my view, is Min Metals, which Justice Rick says is... from a judge who knows about the area and approved of. But in my submission, Justice Ricks misunderstands that, because what is apparent from that case, in my submission, is that it doesn't matter what approach the court of the seat takes.
Where is that?
I'll show you. Sorry, it's slightly out of order, but Min Metals, let me get you that. It is 3682, I think. Yes. And
Which passage?
yes, sorry, I'm just looking up. Yes, so its page starts at 3693 under the heading "The Inability to Present a Case Issue."
Just a second.
You have that. Although many of those states who are parties to the New York Convention are civil law jurisdictions, or are those which, like China, derive the whole or part of their procedural rules from the civil law, and therefore have an essentially inquisitorial system. Now, just pausing there, the issue of iura nova curia and having an inquisitorial system, in one sense, are related, which is there's an approach which is different from the common law. So what Mr. Justice Coleman was saying here is that civil law systems have an inquisitorial approach, contrary to the common law systems. But then he says, Article 5 of the Convention protects the requirements of natural justice reflected in the audi alteram partem rule. So in other words, what's obvious immediately is that the right to be heard and the inquisitorial system are not necessarily compatible, and one can see that by undertaking inquisitorial exercise, the parties might not have a right to be heard if you simply go ahead and investigate matters.
What's the basis for him saying this?
That is a general approach. I think it's well known that civil law systems...
That Article 5 is reflecting something else.
Well, he goes on to, I think, to explain that. Therefore, where the tribunal is procedurally entitled to conduct its own investigations into the facts, the effect of this provision will be to avoid enforcement of an award based on findings of fact derived from such an investigation if the M4C had not been given any reasonable opportunity to present its case in relation to the results of such investigations. So what the judge is saying is that if an inquisitorial exercise is undertaken, that isn't an answer under Article 5 because the parties have a right to be heard, and therefore you've got to give them notice of your investigations.
So what is he saying? That flows from the convention independently of any national system? Or?
Yes, I think he is saying that. Yes, he is saying.
He's not explaining it.
No. Let's just yes. Well, yes, but it does make complete sense as well. I mean, it is intrinsically sensible, which is that if you are not given the right to be heard is a fundamental right of fairness enshrined in Article 5, explicitly referred to. And you can't, what he's saying is you cannot avoid that simply by a civil law system having either, in this case, investigatory powers, which are permitted by the law of the seat. Similarly, iura nova curia, which is to do your own investigations. You've always got to give notice to the party. And then he says, well, Article 26 of the CETAC rules, he says that the party shall give evidence for the facts on which their claim or defence is based. The arbitration tribunal may, if it deems necessary, make investigations and collect evidence of its own initiative, embodied in the rules. This, however, was not treated by the Beijing court as permitting the tribunal to reach its conclusions and make an award without first disclosing to both parties the materials which are derived from its own investigations. That quite distinctly appears from the grounds of the court's decision, that FERCO was, for reasons which it could not be responsible, unable to state its view. Those reasons could only have been its lack of prior access to the subsale award and the evidence which underlay it. I conclude it was to give FERCO's lawyers an opportunity to refute this material that the Beijing court ordered a resumed arbitration. So in my submission, what the judge is saying there is that there is a priority. Yes, can I? Yeah, just actually another passage over the page at 3696 at letter I. In my judgment, the inability to present a case to arbitrators is within Section 103(2)(c contemplates at least that the M4C has been preventing his case by matters outside his control. This will normally cover the case where the procedure adopted has been operated in a manner contrary to the rules of natural justice. So what Mr. Justice Coleman is effectively saying is that the right to be heard is a fundamental right that can't be trumped by investigative procedures where the parties haven't been given notice. And we would say similarly here in Euro Novit Curia, where we haven't been given a notice of the point that was ultimately decided against us.
The rules of natural justice, which rules is he referring to?
The right to be heard, I think, is what he's referring to here.
Even if the effect of the principle in some civil law systems is that there's a right, as it were, to be heard on the facts, and then it's up to the court or the tribunal to decide the law.
Yes.
And you don't get any notice.
Yes, I do. That is our submission. That's the heart of this part of the case, which is simply by agreeing a civil law seat can, for example, let me give you an example. A sole arbitrator and a civil law seat goes and does an independent site visit, doesn't tell the parties, reaches a view on the quality of the building or whatever it may be, makes findings in his award. Neither party have had any opportunity whatsoever to comment on that or make submissions or put in evidence in relation to that. First time they read it is in the award. In my submission, that's plainly not...
That's on the facts, though, isn't it? I mean, that's... Is it not?
Well,
that's a determination. Well, I suppose it might be said to be a...
Does the choice of seat affect the procedural law of the arbitration?
It
doesn't in this case.
In an ICC arbitration, it doesn't. Unless
so you say in this case, it's actually got nothing to do with where the seat is. What the procedural rules or fairness, principles of fairness that the arbitrators apply.
Exactly. In this case, I would say that, but I would say particularly in this case because when drawing up the terms of reference, the parties are free to say, ask the tribunal to apply particular rules. They can say, we would like you to adopt the law of procedure of the Brazilian court, and that may or may not be accepted by the tribunal. But once the terms of reference are signed, that's it. And so
all they've chosen here is the substantive law of Brazil to govern their contractual obligations.
Exactly.
They haven't chosen the law of Brazil as the law of the procedure that the arbitrators must follow.
Yes.
So what is the procedural law that they have to follow? I mean, are we talking about some sort of minimum international standards, and if so, where are they set out?
Well, the guidance is given in the terms of reference itself as to the procedural approach to the arbitration.
Do the ICC rules have anything relevant?
I think only what I've told your Lordship, which is that you're required to see whether there are any particular procedural rules that apply.
So it's up to the arbitrators to decide on their own procedure within such constraints as the
parties may
be on them.
Exactly, all the submissions the parties may make. So your Lordship's right. It doesn't apply in this case because this is an ICC arbitration. It wasn't in the terms of reference. The other point that we've made in our case, which is that we don't accept that Euro Novit Curia applies unrestricted in the context of an international arbitration. So we don't accept even the first base, which is that when you're applying the law of Brazil, it necessarily, in any event, incorporates the Euro Novit Curia without limit. In other words, the ability not to give notice in an international arbitration context. That was one of the areas of debate. So our case was, even if Euro Novit Curia applied unlimited, not in an ICC context, the position in Brazil is limited because notice does need to be given. And the ICC, the guidance in the Secretariat does say that not in the rules themselves, but they do say that notice should be given of any points that would surprise the parties. And you've got that in the bundle.
I didn't see this in Manana Friend's case, and it was dropped in the Court of Appeal as a point.
Well, we've got
Which particular point are we talking about? This is where the ICC rules...
Yes, Euro Novit Curia doesn't apply because it's an ICC arbitration. That was run before Mangatel. It was run in the evidence. Wasn't run in the Court of Appeal, and I didn't see it in the case.
Well, I think... we've given you the extract from the...
So what you said a moment ago, wasn't the ICC rules you referred to, but something else?
Yes, that was what I was referring to, which is the Secretariat's Guide to ICC Arbitration, which is in your bundles at 5152. 5152. If you don't have it, there was a separate supplemental authorities bundle.
Yes.
And it's paragraph 3770, about 6 lines down.
Sorry.
It's the last page of the supplemental bundle.
Yeah, it's 5162
Oh, got it,
or
yes.
38 of 38, if you...
Sorry.
Yeah,
5152 is page 38 of 38.
Yes.
Yes.
Right, and that's where we are, 3770.
Absolutely, and it's 6 lines down. If an arbitral tribunal is contemplating the application of legal concepts not argued by the parties, it should seek to uphold due process by presenting those concepts to the parties and inviting their comments, which is unsurprising guidance in an ICC arbitration.
Yes. Yes.
Now, could you assist me, please? What is the status of this document?
Of this, in the appeal, you mean?
Yes.
It's an authority that we rely on.
It's a guide.
It's a guide.
Yes, and assist me. What value does the guide have in?
It shows best practice.
Right.
Shows best practice. And it is an indication of what the parties would expect when they agree ICC arbitration.
Thank you.
The next case I was going to show you is Malincourt, because there are some similarities between that case and the present case.
That's the decision of Mr. Justice Walker, is that?
That's absolutely right.
Yeah.
My Lord, yes. It starts at 3669. I'll just tell you what the facts were. Malincourt, the plaintiff, had pursued a claim against Egypt for compensation for breach of contract. The tribunal rejected the claim, but they instead held Egypt liable to Malincourt under Article 142 of the Egyptian Civil Code. Article 142 hadn't been pleaded or argued by Malincourt, nor had been raised by the tribunal until the award. So you can see why we say there are some similarities.
It's a particularly extreme case, because effectively, having found that Egypt won, the tribunal then found against them on quantum, which is rather bizarre.
But I would say not quite so, no more bizarre than this case, actually, when you take a step back.
I mean, you may be right in saying that it establishes a principle that's applicable in the present case, but okay.
And I'll just, if you go first to, I think, to 41 and 42 of the judgment, which really, that's at page 3681.
Yeah.
And at the bottom of paragraph 41, Mr. Justice Walker says there were undoubtedly strong arguments for Egypt to advance in these respects, among others. The notion that in the absence of any mention of these matters, Egypt could and should have anticipated the basis of proceedings adopted in the Cairo Award is, to my mind, manifestly repugnant to elementary principles of fairness. And then if you go back to 3678, paragraph 31, relevant legal principles, there can, in my view, be no doubt that a grant of remedies on a basis which was neither pleaded nor argued will be capable of falling within this subsection, nor can there be any doubt that, under principles of English private international law, the test as to the ability of the party to present its case involves an application of relevant English principles, as opposed to those of Egypt or anywhere else. See Kukurova. So again, that emphasises the point that the principles, fundamental principles of fairness, are those that trump the whatever is permitted in the court.
Kukurova was referring to the public policy ground, wasn't it?
Yes.
And it seems to be common ground in that case. He's now talking about the unable to present your case.
Yes, unable to present your case. There are two, under Article 5, there are two issues. The right to be heard in my submission trumps any unfairness by not giving notice.
This is dealing with section 103.2 C, which is the right to present their case.
Yes.
But it's reflecting is Article 5, 2C. Is it? Yes. B, sorry, B.
5.1b, yes. So in my submission, under 5.1b, you have a trumping under the New York Convention, if I can put it that way, of fundamental issues of fairness. If you haven't been given the opportunity to be heard, then that falls within that section, even if process was permitted by the court of the seat, because it cuts across that fundamental fairness. When you're in 2b, and it talks about public policy, that can be a weighing up of different public policies and can include taking into account the procedures and practices of the court of the seat, whatever they may be. And that will be a balancing exercise. But that doesn't apply under 1b because you have a right to be heard, a fundamental right to be heard. And that's enshrined in the New York Convention. So that will trump, in my submission, any inability, even if what was done, for the sake of argument, was permitted by the court of the seat.
He's saying you apply English principles here. It's just Coleman was unclear as to exactly what basis.
Yes, I think Mr. Coleman was approaching it as simply a construction of the New York Convention itself. He wasn't tying it down in any way. He was stating the broad principle which we adopt, which is that if you haven't been heard on a point, that is a breach of the fundamental requirements of fairness, and it's irrelevant that unfairness can be justified by reference to the laws of the seat.
I mean, looking at it as a matter of principle, you might argue, might do, that it's an international convention and it should be given an international interpretation, unless it says that, or interpreted in accordance with broad international principles, unless it says you apply, as it does in some provisions, you apply the law of the country where the award was made, or something else.
Yes.
But are there examples internationally of an international interpretation being given? I think we need more assistance on that.
It's hard to believe there isn't more to bear on this, and that we should be interpreting it by reference to the limited authority you've taken us to.
I think you have the English authority, but you don't have the global reach.
That's the point, I think, that we're just asking about.
Yes, understood.
You're putting it as a global point.
Yes.
Yeah. Well, this paragraph 31 is putting it in terms of English public policy.
Yes.
And it's not looking at it in terms of any sort of international standard. But is there a case, not necessarily an English case, but any other case that indicates that international standards do apply? And if so, what does that mean?
Well, you have included a passage from de Burgh, I think, who says that academics argue for an international approach and courts have tended to apply their own, or something along those lines. But
yes,
there's potentially a lot more material on this.
Well, we do say that our approach is consistent with an international approach, but I accept that you don't have the material. So would happily provide that if that...
I think we should be providing
Yeah. So before I leave that point then, you will give us guidance on precisely what you want after the hearing? Yes?
Well, it may be you can assist us during the course of the hearing, but...
Yeah, I think it would be very difficult, though, to deal with that on the hoof. It's just a global reach of the New York Convention and which jurisdiction take which approach. I think that would be really quite difficult. But yes, I see that we've focused on the English authorities.
You can develop the argument anyway that just on general principle of fairness, as it were, whether or not you did have a fair...
yes, absolutely. No, I mean, there's plenty more to say.
I mean, I think what you say is I mean, you say the judge said decided this is a matter of public policy of the Cayman Islands, which for present purposes is the same as public policy of England.
Yes.
And that was correct.
Yes.
And the Court of Appeal was wrong to overturn her on that issue.
Absolutely. One of the criticisms we make of Justice Bill Ricks is that he said that he found this difficult to reconcile with the doctrine of iura novit curia. And we don't accept that there's any difficulty in that respect, because it isn't an attack upon iura novit curia itself, nor does it ignore iura novit curia. It's never been our case. It is simply that where an issue of law arises which isn't pleaded, in an international arbitration, the parties need to be given notice in order to deal with it. And so it's quite limited. It doesn't attack that process any more than Min Metals was an attack on the inquisitorial process of civil jurisdictions. It doesn't attack anything. It simply requires that in an international arbitration context, notice must be given of any point, such as Article 1.
It's perfectly open to the tribunal to come up with their own point.
Yeah, to tribunal. Yes.
Alert the parties.
Absolutely, absolutely. I think that's absolutely right, which is that the tribunal may well have a point, or they may consider that the parties haven't addressed the correct result, so that they want to reach a different result. Now, they are perfectly entitled to raise that with the parties. If here the tribunal had said, we would like to take submissions on Article 148, and we want to receive evidence on 148, and we want legal submissions, there wouldn't be anything in my complaint. They can do that. What the result of that would be a different matter. But proceeding straight to an award where the first time the party sees the result is in the award itself is, in my submission, quite wrong. Now, that's consistent with English normal practice. That is also consistent with serious irregularity issues, which raise different issues, which is the one of the few areas where serious irregularity challenges succeed, is where you haven't had an opportunity to address a case which is decided in the award. So our submissions are entirely consistent with that, which is that the tribunal are perfectly entitled to come up with points, provided it tells the parties. But what it can't do is what happened here, which is suddenly... And this
it's a matter of degree, isn't it? Because you can come up with a new argument or a new authority and it wouldn't be a ground for attack. But you say this was a whole new basis of claim, was outside the terms of reference.
There are limits, I think, even in a common law system like the English system, which is where the judge starts to refer to authorities that weren't cited by the parties. That is a question of degree, often unobjectionable. But that is definitely a matter that could...
well, you would say it would be good practice if the judge or the tribunal come up with some authority that might actually be determinative.
Quite.
But they should give the opportunity to be...
Absolutely.
To make submissions.
And often, obviously, in this jurisdiction, that is often what is done, which is the judge, I've been alerted to a new case. Can I take your submissions on that? Rather than just dealing with himself. But, of course, there are limits to that. But this is a whole claim. And a claim that's inconsistent with the claim that was advanced, inconsistent with the basis for jurisdiction in an international arbitration context, where it's not even in the terms of reference.
Perhaps over the adjournment, you would just consider with those instructing you and those assisting you.
Yes.
What more assistance you think you may be able to give us on this point.
Yes.
And how long and in what manner you think you would be in a position best to provide it to us.
Absolutely.
And perhaps also have an opportunity, should it arise, for you to discuss this with Mr. Lowe.
Yes, quite. I think we've had a very strong hint from Lord Legate as to at least one of the texts that might be useful for the tribunal. I will see if it's possible to deal with that. I have an hour in reply, whether I could do that tomorrow, but I'm just, the task could be quite large.
I'll take it under advisement, those around you, and please discuss this with Mr. Lowe.
Absolutely.
If at all possible.
Yes.
I don't know if it helps, but the Secretariat Guide on the Convention, which is in your Lordship's papers, does actually deal internationally. The short section does deal with 51B. I don't know if that helps at all. It's 3958.
Thank you.
So that's in the supplementary bundle.
No, it's in the bundle of authorities that were before the hearing. It's my client, but it's
Give me the page again, 39.
3958 is in the body of the document.
Again, if you're not familiar with this at the moment, it may be something that you'd like to return to. You must take your own course on that.
Yes, absolutely. One other point I should make on the fact that it's an international arbitration is what the point that we make in our case, which is it's particularly important in international arbitration that notice is given because the arbitrators may not themselves be versed in the system of law which governs the arbitration. It's quite different to a court hearing where the judge is obviously versed in the system of law that he or she is applying. But in an international arbitration, that may well not be the case. The other point is that it appears in the Court of Appeal to be suggested that the point on Article 148 was sufficiently raised. Now, we deal with that in our case at paragraphs 92 and 93. We submit there's nothing in the point. In Malachor, which I've already shown you, damages were ordered under Article 142 of the Egyptian Civil Code, and that provision hadn't been pleaded, raised, or argued in the proceedings. But it's the same here. It wasn't pleaded, raised, or argued. Indeed, it was contrary to the basis for the jurisdiction. So the idea that it was sufficiently raised and that my client should have anticipated a point which was inconsistent with the basis upon which the tribunal found jurisdiction in my submission is nothing to the point. The other case that bears on this is Canoria, which is in the bundle at 3663. 3663. It's a decision of the Court of Appeal where there was a case of the M4C being personally liable without any notice whatsoever of the personal claim. And its first passage is paragraph 23 on page 3667. Paragraph 23 on the right-hand side, there is not much authority on the meaning of section 103(2)(c) of the 96 Act. In Minmetal, as Mr. Justice Coleman observed, in my judgment, the inability to present a case to arbitrators within section 103(2)(c) contemplates at least that the M4C has been prevented from presenting its case by matters outside its control. This will normally cover the case where the procedure adopted has been operated in a manner contrary to the rules of natural justice. That observation accords with the interpretation that I have reached in relation to that clause. It also appears to receive the approval of Buxton J. Inavani. Now, even in a serious irregularity case, which are difficult to establish, it's a breach if an arbitrator fails to give the parties an opportunity to put their case. If I can just show you also paragraph 32, and 22, just for 22 first, on the left-hand side of 3667, 3 lines down, it seems to me quite clear on the natural wording of that clause that a party to an arbitration is unable to present his case if he is never informed of the case that he is called upon to meet. And then just finally, Lord Justice May, at paragraph 32, actually it's quite useful to see, instructive to see paragraphs 29 and 30. Lord Justice May says, the limited circumstances which an English court could be persuaded to refuse recognition or enforcement of an arbitration award to which the New York Convention applies are those to be found in sections 103(2) and 3 of the Arbitration Act. The authorities make clear that the court is not concerned to investigate the merits of the dispute, which is the subject of the award. Section 103(2) and 3 are more concerned with the fundamental structural integrity of arbitration proceedings. And then at the bottom he says, speaking generally, that is not surprising when the limited circumstances in which an English court can be persuaded to refuse enforcement of a New York Convention will concern, I think, the structural integrity of the arbitration proceedings. If the structural integrity is fundamentally unsound, the court is unlikely to make a discretionary decision in favour of enforcement. And then on the right-hand side, halfway down paragraph 32, it is elementary in this jurisdiction that a case of fraud may not be advanced without the party alleged to have been fraudulent having been given due notice of it. No apparent case was made against Mr. Guinness in the written case that was made and served on him to that effect. The failure to give him notice of this kind of case, such as I've described, does, I think, amount to a failure in the nature of a breach of natural justice. I agree it comes within section 103(2)(c) of the 96 Act. Mr. Guinness was not given proper notice of at least a highly material part of the arbitration proceedings so far as he was concerned. He was unable to present his case because he was never given notice of the basis of the case against him personally. And you'll notice in that case there was no mention of having to show any sort of causation that it made a difference, or for the court investigating the merits. In Al-Shamsi, I don't need to take you to that, it's page 3713, but Mr. Justice Popperwell rejected a case that there was no opportunity to be heard in that case because the claim was expressly pleaded, paragraph 94 at 3733, and raised 3 times in that case, paragraph 109 at 3737, and that was held to be sufficient notice. But that's not this case. In this case, it wasn't pleaded in the terms of not in the terms of reference, and is fundamentally inconsistent with the basis that it was held that we were a party to the PSA. So I'll just turn next to the causation point, which is this
was the factual allegation of fraud that was alleged, was it?
Yes, it was a rescission, I think, the argument in that case. It was whether or not...
No, in our case.
I don't...
There was a finding of fraud by the individual whose knowledge or conduct is attributed to your clients.
Yes, that's right. Mr. Lapchan, that's correct.
Yes.
Yes.
So that was on the table, was it?
That was in the evidence, yes. Elements of that. We've set it out in detail in our case.
But I think it's set out in the award that at least in their closing submissions, the claimants set out what they said was the effect of the evidence, namely that there was fraud and there was malice. I mean, they did say that.
Yes, but all in the context of a contractual claim under Article 5.
Well,
yes.
That I follow, but...
Yeah. No mention of Article 148, nor any application to amend the terms of reference, which if you're going to do that, that's what you would need to do, all directed to Article 5. So that's correct. There were some facts about Mr. Lapchan and what Mr. Lapchan did, but in my submission that doesn't begin to justify a finding under a provision that wasn't pleaded, not in the terms of reference, and under a different cause of action, in tort rather than contract.
To amend the terms of reference, they have to go back to the ICC, would it?
No, they could go before the... Well, you make an application to the tribunal, and the tribunal would approve it. Approve the...
It doesn't have to be approved by the Secretariat.
No. It wouldn't have to be approved by the Secretariat, no. So, and that wasn't done. So, my next point is causation on this, because what's said against me is by Justice of Appeal Riggs, in paragraph 174 of the judgment, that the MP funds had to prove the lack of opportunity would have made a significant difference. Now, in my submission, there was no principled basis for the application of that test. There are 2 issues. The first is it confuses the test for serious irregularity in England under the Arbitration Act 1996 with the test under the New York Convention.
But does he actually apply that test, or is that just an additional point?
Well, he applies the test of... He says that my clients had to show that the lack of opportunity would have made a significant difference.
Well, can we just have a look at...
Yes, of course. It's page 150 of the bundle. At 174 of the judgment. If you look at 3 lines from the bottom... Well, actually, it's probably worth reading the whole. Although it's possible and acceptable to consider that due process and public policy can be tantamount to the same thing, at any rate in cases where the breach of due process constitutes a negation of substantial and natural justice, it also needs to be remembered that breaches of due process come in every degree, from the most insubstantial to the most outrageous, which is why the English Arbitration Act will only give effect to a challenge of an English award based on due process, i.e. serious irregularity, if the complainant proves substantial injustice as well as serious irregularity. That's written into the Section 68 statute.
Right,
For that purpose,
he finds against you regardless of that point, doesn't he? Because
yeah, he says, well, yes.
So in any event.
Yes, he says that we needed to apply in the New York Convention territory, the lack of opportunity would have made a significant difference. And we say, in the context of the New York Convention, there isn't any supporting principle or authority for that test.
Significant difference test.
Significant difference, or indeed any test, actually, because the New York Convention sets itself against investigating the underlying merits. The purpose of the New York Convention, when you're applying Article 5, is not to look at the merits, underlying merits of the award, or investigate.
But there are some courts, aren't there, that have applied some causality requirements?
Yeah, I'll show you what Vandenberg says about it. But before I do that, can I show you in our supplemental bundle, Fouchard, the extract from Fouchard, which is at page 5130 or 16 of 38. It's in the separate bundle. Yeah. Paragraph 1699. The Convention censures a breach of due process per se without making the refusal of recognition or enforcement subject to proof by the party resisting enforcement of damage suffered as a result of the breach. In itself, a breach of due process is considered to be sufficiently important to justify such redress without the need for the party invoking it to establish actual damage. And we submit that's what happened in Canoria, in the Guinness case. There was no suggestion.
What's he referring to there?
125. He says, I think it's footnote 25, yes? That's Vandenberg, a reference to Vandenberg.
Well, in those contexts, it's not a good argument to say you didn't have to have a fair hearing because it wouldn't have done you any good anyway.
Exactly. That's the point. The highest it can be put is in Professor Vandenberg's seminal work on the New York Convention, which you've got in your bundles, in 4241. Sorry, 3421. And it starts actually at 3420 at the bottom of the page, the fourth and last question. Do you see that?
Sorry, what page?
3420. Yeah. Fourth and last question is whether a serious violation of due process may lead to a refusal or enforcement of the award if the arbitral decision would not have been different in case the irregularity in the procedure had not occurred. This question was, which is a slightly different question, but the question was considered by a court of appeal in a case where the arbitrator had not forwarded a letter submitted to him by the claimant to the respondent, who was consequently unable to express his views on this letter. The court of appeal considered that a violation of due process cannot be cured as soon as it cannot be excluded that the arbitral decision would have led to a more favourable decision from the respondent, which the court found to be the case. This would mean that if it were beyond doubt that the arbitral decision would have been the same, a serious violation might not lead to a refusal of enforcement of the award. So just very important to see the words, if it were beyond doubt that the decision would have been the same. He then goes on to say, the point of view of the Court of Appeal of Hamburg is a pragmatic one. If it is clear that the arbitral decision could not have been different, that had the irregularity in the procedure not occurred, it would seem to make no sense to refuse enforcement. So our submission is that either there is no test here of causation, one shouldn't enter into that, but the very most that it could be said is what Professor Vandenberg says in this book, which is if you can, as a matter of pragmatic process, show that the decision couldn't have been different, i.e. it's beyond argument, it could not have been different, then it makes no sense to refuse enforcement. And then he says, a legal justification for this point of view can be found in the opening line of paragraph 1 of Article 5. Recognition and enforcement of the award may be refused. It is to be approved that the Court of Appeal was very cautious to this effect by exercising a marginally negative control.
It becomes a question of discretion at that point.
Ultimately a question of discretion, but to be exercised on these principles, which is the starting point is that you don't, that causation doesn't enter into it, that you don't investigate the merits. But if a party can show, essentially beyond argument, that it's clear that the arbitral decision could not have been different, then you might, on the basis of this extract of Vandenberg, get home. But basically, we're in the territory of no test, because if you've been not given the right to be heard, you don't have to prove that it would have made a difference at all. Or Professor Vandenberg, which is, if you can clearly show that the arbitral decision could not have been different. And then at the bottom of the paragraph, he says, a court before which enforcement of a convention award is sought may, in my opinion, not go further, as this would amount to an extensive examination as to how an arbitrator would have decided if the violation had not occurred. The latter would yield to a review of the merits of the arbitral award, which is excluded under the convention. So in answer to my Lord Hamlin's question, which is, are there cases under serious irregularity, the statutory test, that's different to under the convention for the purposes of enforcement. And at the very most, it is what Professor Vandenberg says, which is you can clearly show that it wouldn't have made a difference, but without getting into the merits.
Otherwise, you're wading into the merits. Which
As soon as you wade into the merits, and wading into the merits on a New York Convention case is impermissible. It's very different to serious irregularity under the statutes.
But even under serious irregularity, there are some types of irregularity that it almost goes without saying. Didn't we address that in the argument?
Yes, exactly. We did.
So what Buddhist Rick says here is inconsistent with that.
He also, what he also says is inconsistent, which he says in trenchant terms on the serious irregularity point. I have no doubt that the same is true for the purposes of a due process challenge in the Cayman Islands to the Cayman Award. He assumes that the Cayman Islands statute is the same as the English statute, which it isn't. The Cayman Islands statute adopts the test as in the Singaporean statute, which is one of reasonable arguability, rather than adopting the English statute. So he said, I have no doubt the same.
When you say, you mean in terms of section 68?
Yes, in 68. So this is now dealing with serious irregularity.
Reasonably arguable that there's been a serious irregularity.
Yes, exactly.
As opposed to having to show substantial injustice.
Yes.
So it's a false point anyway.
It's a false point anyway, but he's wrong to say in trenchant terms, I have no doubt the same is true in the Cayman Islands, because they adopt a different statute to the English statute. But even under serious irregularity, I think as Lord Hamlin was saying, it's a question of degree. It really is one of reasonable arguability under V networks, which is, have you got a reasonably arguable case that would have made a difference, even under substantial injustice test. And that was, again, Mr. Justice Coleman in V networks. So whichever way you look at it, it doesn't work. But we're not looking at serious irregularity for this purpose. We're looking at New York Convention. That sets its face against an investigation of the merits. At most, the test is that identified by Professor Vandenberg, which is it's clear it wouldn't have made a difference. But otherwise, the court doesn't trespass into the merits. Once you're...
What's wrong with the Vandenberg test?
I don't say there's anything wrong with it. The only problem with it is when it's applied, applying practically. I do accept, it's one of two things. We primarily say there's no intervention at all, but one can see the pragmatism in that approach. The difficulty with it is one can see that there'll be arguments about whether it's clear whether it made a difference. So it's the practical application. Yeah. Professor Vandenberg says this is a practical, pragmatic step the Hamburg Court of Appeal decided, because on the facts of that case, it couldn't have been different.
Well, it might be thought rather odd if it is clear that it would not have made a difference, that it should nevertheless be fatal.
May depend on the nature also of the lack of due process.
Yes. Yeah. Yes.
Some can be so fundamental that perhaps you really haven't had a hearing at all. But
yes.
And that's the point that Mr. Justice Popplewell was making in Terma, which was quoted by Sir Bernard at 175.
Yes.
Where the conduct is so far removed from what could reasonably be expected from the arbitral process that justice occurs.
Yes, but that is, you see, that's the serious irregularity. And I do think it's important to separate serious irregularity, which is, under Section 68, that can encompass a vast range of challenges. You have the vast majority fail. But as I say, the one area where they can succeed is where you haven't been heard. And on this hypothesis for this test, we're in the territory of not having been heard on a point. And that's why My only hesitation about Professor Vandenberg's test is the practical application of that test. It's only that. But provided it's approached on the basis that one doesn't enter into the merits, we are here dealing with a failure to be heard on an issue. And in my submission, it's either one of two answers. Either you don't go into causation at all, or if you do, it's Professor Vandenberg's test. But that needs to be approached with some caution, because there'll be potentially arguments about whether that test is satisfied in a particular case. And as I say, in Canoria, in English domestic proceedings, there it was personal liability, no notice of that whatsoever. There was no mention of causation, no mention of Mr. Guinness having to prove that he wouldn't have been liable anyway. The court shouldn't enter into the merits on those types of cases. But I think, before I leave this, I think it is important here that one separates out due process challenges under the law of the seat, i.e. the statutory test in England, Section 68, and the test under the New York Convention. They're very, very different. And Section 68 does allow, in certain circumstances, investigation of merits for the purposes of the application of the test, but the New York Convention does not. The other point here is that we do submit, in our case, I don't really need to take you into any detail, but we do say here it would have made a difference. We were liable under Article 148 on a third-party mallet tort claim. The claim we were meeting was a contractual claim under Article 5 of the contract. In my submission, under Brazilian law, it's plain that there would have been submissions to be made on the applicability of Article 148 if we'd had that if we'd been given that opportunity. But it's not something that this court can easily take a view on.
Will you be saying how could we be liable as a third party?
Yeah, how could we?
To the contract if, as you found in your first award, we're parties to the arbitration agreement and therefore to the contract.
Exactly. And also how the measure of damages changes.
And there might not have been answers to
exactly.
that. We can't inquire into that because that's doing the very thing that the Convention doesn't permit.
Exactly. And also, you couldn't do it here because it's Brazilian law. Even if it were English law, I would be submitting that it wouldn't be appropriate to do so. But the idea that the court can take a view on Brazilian law approaches to tort and contractual damages under their code is I think, very wide of the mark. The other thing that the judge says, Justice Peel Ricks, is that it was an ICC award and therefore the approval by the court was of significance. But the ICC court approves all awards. And we submit we don't understand how it's relevant to the issues in this case. We don't know. The court doesn't reveal what it does. We don't even know whether the ICC court was even aware of the 148 point and whether it had been taken.
What about the Brazilian court's decision that there was no failure of due process, assuming that was the decision? Yeah,
assuming that was the decision. Well, that's a different factor. I mean, that comes into the separate issues of challenge in the seat and what is appropriate in the seat, as you get with investigations and Euro Nova Curia, and how that interplays with Article 5.1b. If you have, even if it were the decision of the Brazilian court that it was permissible under Brazilian court procedures and Euro Nova Curia not to give notice of Article 148, that is a separate issue. Even if that were the case, that is no, in my submission, no answer to 5.1b, because it's a fundamental right in Article 5.1b. We have a right to be heard, and that breached fundamental issues of fairness, regardless of what the court of the seat decides and whether it's appropriate in those circumstances. And that would be my submission even if it weren't an ICC arbitration. But the fact that it's an ICC arbitration in my submission makes the point even stronger. But if it were a sort of ad hoc arbitration, it wouldn't make any difference that the local court says that this is permissible. It simply means that you can't challenge, i.e. you don't have the equivalent of your Section 68 procedural irregularity. The local court says there hasn't been a procedural irregularity. But that doesn't affect the analysis in my submission under Article 5.1b. You have a fundamental right to be heard, and if that is breached, you have a defence to enforcement under Article 5.1b.
And that's your focus, Article 5.1b.
Yeah. And well, the other is 5.2b. It's different. We put it in both ways. But one can see it's a more nuanced argument where you're balancing public policies.
Well, realistically, if you don't succeed under 1B, you're
Yes.
not going to succeed under
I think that's
the importance.
I think that is a very fair way of putting it. Absolutely, absolutely. But just to make the point, 5.2b is a balancing of public policy in which we would say that yes, you do take into account the approach of the court of the seat, and you have to balance the various interests. I should just say on that point that Ms. Justice Mangatal held that the full extent of Jura Nova Curia didn't apply in international arbitration and Brazilian law. She accepted our evidence on that and rejected VRG's evidence. That's in the judgment of 179, page 81 of the bundle. Mr. Justice Appeal Ricks took his own view on the basis of a textbook which neither expert had relied upon and which he said was inaccurate in respect of English law. And we set out in our case, we say, well, if one looks at the textbook, it actually doesn't support that anyway, because so far as Brazil is concerned, it says that Jura Nova Curia applies in domestic arbitrations. That's what our expert said. It applies in domestic, doesn't apply in international arbitrations, where a much more cautious approach is taken. That you'll all find that in the judgment of Mrs. Justice Mangatal. That is in her judgment in the bundle at EF 146. But it's very important that the judge at first instance found in favour of our expert evidence that the full extent of Jura Nova Curia doesn't apply in international arbitration under Brazilian law anyway. Just very quickly, I see I've got a little bit of time. Just the third ground. Article 148 was beyond the scope of the submission. And that arises under New York Convention Article 51C. It's a defence to enforcement where the award deals with a difference not contemplated by the terms of the submission to the arbitration or matters beyond the submission to arbitration. In English terms, the award deals with matters beyond the scope of the reference. And I emphasise that because the way it was dealt with below was to say that Article 148 could or did fall within the terms of the arbitration agreement, but that's not the issue. The issue is, did it fall within the terms of the reference? In an ICC arbitration, the scope of the reference is defined by the terms of reference, and it was common ground, I hesitate, but I believe that to be the case, and accepted by Professor Colmona, that a tribunal cannot order relief which is not requested by a party, and in an ICC arbitration, that's determined by analysis of the terms of reference. I'll just show you where that is in the bundle. It's page 497. It's page 105, line 14. If you see, actually, if you just go above 14, that's me asking questions. Starting at line 5, Professor Colmona says, the parties were fully entitled to articulate the legal grounds that they submitted were applicable to the facts of the case. However, in making its determination, the arbitral tribunal was not limited by the submissions of the parties as to its legal grounds or the specific articles of the piece of legislation applicable to the dispute. The arbitral tribunal was only constrained in its decision-making by the factual issues raised by the parties, and could only have awarded such relief that had been requested by the parties. Yes, that's correct, thank you. By definition, you would agree, would you not, that a tribunal cannot award relief that is not requested in the terms of reference? That was my question. The tribunal cannot award relief that is not requested in the terms of reference. Yes. And article, as I've shown you, Article 5 was within the terms of reference. Article 148 was not. There's no reference to 148 in the terms of reference, and the relief claimed was plainly contractual and contractual only. And we don't agree with the finding of the Court of Appeal at paragraph 191, where it says that the language wasn't sufficient to designate such a claim as contractual. It's absolutely plain in my submission when one reads the terms of reference, it was a contractual claim. The word said, grant the price adjustment provided for in clause 5.1 of the contract. Those are the terms. So we say the first error was to misread the plain words, and the second error was to have undue deference to the curial court.
So what standard is he's giving an opinion about Brazilian law, is he?
Yes.
And that is the law that a Brazilian court would apply in what context?
Well, that's very difficult to follow, actually.
Enforcing an award, when it's a challenge to the integrity of the award attempting to annul it?
Exactly. It's very, very difficult to work out the basis.
I know it's in your favour, but I'd like to know what he's telling us about that.
It's because we do say in our case the reasoning is very difficult to follow. But in any case, actually, but particularly in an ICC arbitration, and the standards of the Curio Court aren't an answer to this. What the Brazilian court would have said is neither here nor there. This is about the terms of reference in an ICC arbitration. How one gets into Brazilian law reviewing that, it's very difficult to see, except if the Brazilian court is simply deferring to the tribunal, which is where it feeds back into our earlier point, which is what was the Brazilian court doing? How can there be an estoppel on this? Unless...
Well, there could have been a challenge to the... Was there a challenge to the award on the grounds of fairness in the Brazilian court?
Yes, there was.
And so in that, I guess under their equivalent of Section 68 or whatever it is, that's perhaps what he's talking about here.
Yes, that's possible. But as I say, again, that's one of the things that the court would need, a court outside Brazil would need guidance on, and for that to be explained. It's very, very difficult to follow that logic. And we say that in any event, the standards of the Curial Court are not an answer to due process breaches.
That's a separate limb of the New York Convention anyway, if it's annulled by the court of the Supreme Court.
Yes, exactly. And then the third point made against me is that we were somehow responsible for the error. Now we find that particularly extraordinary in an extraordinary case, that we didn't raise the issue. But our complaint is that we only had notice of Article 148 in the award itself. Wasn't raised by VRG, wasn't brought to our attention by the tribunal, and indeed it was inconsistent with the basis upon which the tribunal had held it had substantive jurisdiction.
Well, the argument seems to be you should have appreciated that that's one of the ways in which they might decide the case against you, and therefore should have addressed it.
So, and absolutely right. And in an ordinary case, one would say this is utterly bizarre. But in a case where the tribunal have already founded jurisdiction on the basis that we're a party, the idea that we should have predicted a claim against us on the basis that we are not a party, in my submission, is very wide of the mark.
Anyway, you say the ground rules are determined by the terms of reference, and if they're not changed, then that's the basis of it.
Absolutely, and not our fault that they weren't changed. That's absolutely right. So there are a number of ways that we get home. So, Kitchen, in answer to your point, in a sense, that ground is a separate ground, and it certainly fits in with the others. It's not one. It may be that in finding if you find in our favour on either of the other two grounds, then it doesn't arise. But
that wasn't the question I asked you.
No, it doesn't. It can be a self-standing ground.
What is the footing of it? Which provision?
This is 1C.
Article 5.1c.
A difference not contemplated by the terms of the submission to arbitration on matters beyond the scope of the submission to arbitration.
Now, is that dependent on the proper... Is that a question for the... For issue estoppel? I'm just trying to see...
Well, you see, that's why...
What the,
I think the case against me is that it's disposed of on ground one. Because they didn't really deal with it in any depth at all. So what is said against me is, if they establish the full extent of their estoppel, we don't get to the third ground. My submission is that, they fail on estoppel anyway. We succeed on estoppel, but it is perfectly possible that this would survive any findings on estoppel on ground one. So it could well be a separate ground on which to find.
You could be a party to the agreement, but the claim may not be within the terms of reference.
Within the scope of the reference.
Within the scope of the reference.
Yes.
One of the grounds in the Brazilian courts was exceeding the limits of the arbitration agreement.
Exactly. When this
essentially covers this.
Yes. Well, the case against me was it exceeded the terms of the arbitration agreement, but this is a separate. This is not about the agreement. This is about scope of the submission.
To the arbitrators.
Yes, and it was dealt with below on the basis that it was a case about it fell within the scope of the agreement. We weren't taking that point. We were saying this didn't fall within the scope.
There could have been separate arguments there about whether the arbitration clause covers tort claims as well as contract. Maybe it does.
Exactly.
If you had been parties to the arbitration agreement,
Yes.
then it was said, well, that the arbitration agreement is wide enough to encompass a claim in tort. But that wasn't your point.
No, that wasn't my point. And picking up on the earlier point, which is if the tribunal had written to the parties and said, we're contemplating making an award under Article 148, can we have your submissions? We intend to amend the terms of reference. I think it would be very difficult for me to say that that didn't fall within the terms of the agreement, the scope of the agreement. It certainly did fall outside the scope of the submission in the unamended terms of reference. So one of the reasons I raise it is below it was dealt with on a false basis, that it was all about the scope of the agreement rather than the reference. So I'm sorry to say that it is potentially a separate self-standing.
No need to apologise. No. Clarify.
I hope that has given them clarification. So those, unless the panel have any other questions, those are my submissions. But I will take away that point about the global analysis and see whether it would be possible to do that orally tomorrow or on some other basis.
Yes,
but I'll do that.
We will obviously want to hear what Mr. Lowe has to say about this before we take it further. But I think in the meantime, for you to take instructions,
I will.
Would be very helpful.
I will, my lord.
And if you have an opportunity to talk to Mr. Lowe, then that would obviously be helpful too.
May I just ask Lord Leggett if you had in mind the document at 3415? It's an extract from Berg's book. 3415. And it deals at 3417, starts to deal with 5.
Oh, yes, when I referred to Van der Berg, I've read that in the bundle. When I referred to Gary Bourne, I couldn't find any excerpts from his magnum opus in the bundle that were relevant to this issue, although there are some excerpts from his book on others. And he has quite a lot to say about it.
In the
Article 5, 1b.
Okay, thank you, my lord.
Very well. So subject to that, that concludes your submissions in opening. Thank you. We will adjourn then until 2 o'clock.